From time to time, we all have setbacks in life, such as we could be involved in a car accident, um, we could have uh, health issues, we could get sick for an extended period of time, we could also be unemployed, also investment loss. In other words, life happens. Hello, my name's Chris, and on this channel, we review the statutes and codes of the Child Support Agency, and we demonstrate and show how it comes into conflict with your rights. On this channel, we provide both private and public education on legal writings. We review decisions, case laws, precedents, statutes, regulations, and from time to time, we provide templates, affidavits, summons, subpoenas. So let's review what is called our non-lawyer maxims. In the case of NAACP versus Buttons, the Supreme Court says that an individual non-lawyer or a group can assist other members of a group in understanding the law. Likewise, in Murdoch versus Pennsylvania, no state shall convert a liberty into a license and then charge a fee thereof. That is, the information we provide on this channel, we provide it under freedom of information. As well as there's other cases that deals with, such as the practice of law cannot be licensed by any state. That is Schwer versus Board of Examining. So let's begin. During the child support process, if you're still on child support, there is a procedure called financial modification, which is different than custody modification. In the child support, they cannot hear custody issues. And this is the confusion. They only discuss financial because the child support agency is a debt collection agency, whereas they can modify existing orders as well as they have jurisdiction on their own orders. They could do upward modifications as well as they could do downward modifications. And in our case, we're looking at a downward modification. Here in New York, the Family Court Act 451, which is similar to the Domestic Relations Law 236, if you're incarcerated or locked up, you cannot halt or stop your child support payment or arrears. So let's look at jurisdiction. In order for the child support agency to hear your request for modification, they must have jurisdiction, and they obtain a jurisdiction from your consent. If you have questions on your rights in terms of consent, we have a video called Defending My Rights. You can learn more about your consent. So arrearage. The purpose of a downward modification is obviously to pay less child support, but it also to reduce what is called arrears. Arrears are the difference between the actual payment that you made and the full payment that they're asking for. They have calculated. For example, a non-custodial parent believes that if they fall behind in their current support payment or they miss payments one or two, they somehow believe that when they go back before the hearing examiner, they can ask for forgiveness or a lower payment. Well, unfortunately, that is not the case. Federal law prohibits what is called retro modification of child support orders, and it's section 466. That is, arrears continue to accumulate, and on top of that, they can charge an interest for those arrears. Now let's review the Child Support Enforcement Agency. As we know, it's an Article 1, or it operates under the executive branch. It is in all 50 states, as well as the federal government reimburses this agency 66% of the cost of operating the program. In addition, they provide incentive payments, that is, goals that they've met within the program. One day we'll do a video on specifically how they're compensated. Also, the program itself is administered at the federal level, but in each state, it is usually administered by the what is called the Department of Health or Department of Human Services. Now, regardless of whether the person is managed at the federal level or at the state level, anyone administering this program is considered operating under the color of law. And the case law is Tongle versus Usury. We have a video called Know Your Rights, which we go into more details. Please feel free to check that out. So let's keep it real. This gentleman, Moses, was wrongly convicted for 18 years, and he was finally released in 2019. But upon his release, he discovered that he has a $40,000 child support payment. As we said, arrearage cannot be forgiven. Now, of course, what he did was he asked the courts to lower or eliminate his child support arrears. And I have the article linked here, which is called for the New York Daily News. Income, your income, the non-custodial income. So the courts treat income in two ways. Either it's modification or imputed income. The court says that they will not rely on a party's income or information. They will do what is called imputed income. That simply means we'll make it up. And the famous case is Cassano versus Cassano in New York, or Kessler versus Kessler. In your jurisdiction, there are cases similar to those, but they arrive at the same thing. Basically, the support manager can make up the numbers. Now, a support manager who will receive your financial modification is hired as a non-judicial officer in New York for 3 years. Now, here's what they don't tell you: that he's not a certified public accountant, he's not a licensed tax preparer, he's not a bookkeeper, nor that person is a financial advisor. So here you have a situation where you're presenting modification of financials to someone who's not even licensed to perform that function. And in return, they're expected or anticipated that they will have 11th Amendment immunity. Of course, that is ridiculous, right? We have a video called The 5 Lawsuits. And number 2 is what we call to sue the support magistrate for fraud. Again, a non-judicial officer operating as a financial advisor. Now, here is the function or the modification process as part of the support magistrate responsibility. Once the magistrate completes his finding of facts, he hands the material over to a judge. Again, the support manager is not a judge. This judge now will conduct what is called a de novo review application. A de novo review, which means the judge reviews the information from the start. So what's the purpose of a support manager if the judge is going to review the information from the start? In addition, the judge will rely heavily on the opinion of the support manager, the support magistrate. And also, the support magistrate or the judge does not have to review the transcript of the hearing request for modification. And during all that time process, your support payments will remain at the same level, and there is no stay while there's a review process. So here's the reality check and a problem. If the judge is the final arbiter of the information, what is the purpose of the support manager? That is because in our belief, we believe that every support manager can be sued for fraud. Now, once the judge reviews the information and you challenge the findings of that judge, you can have what is called an appellate review of your case. Now, here there are several appellate reviews that I have listed on the charts. There were some modification requests under education, professional license, under unemployment, job loss, medical and health. Well, here is the outcome of all of those appellate reviews. They were all rejected. That means you have to write a very compelling financial modification, because if you do not, your arrearage will go up and it will continue to accrue. So it's very important that you write a very good financial modification. So, what have we found in our research? That the one area that the family court or the child support agency hearing cannot change or shall accept a modification from anyone who's getting Social Security disability. And that is Family Court Act here in New York 437-A. And what it basically says is if a modification request as a result of Social Security disability, it must be accepted. So here's a remedy. This is one remedy that you can file right away if you're receiving benefits and you want a downward modification. And the case here in New York is Anthony versus Monique. So in this section is what we call to action. This is where we provide tips and strategies for filing a modification. The first thing you need is your Department of Justice letter. Review that for your rights. Second, you want to collect and assemble your documents. You want to have evidence, important documents such as insurance forms, receipts, anything to prove or to support your modification. Then once you've assembled that, you need to apply for a modification by submitting a petition. Now, this process is an informal process in most areas. Basically, you can follow the format of your jurisdiction, the cover page, the affidavits, and then submit all of that into evidence. If you have questions on filing a modification, please feel free to email us. Now, this brings us to the end of our presentation. I hope now you understand why the importance of filing a modification and that the goal is to reduce your arrears, which eventually leads to incarceration. And at that point, your arrears continue to expand and grow. If you have additional questions, please feel to email us and like and subscribe to us. And we're asking for a donation of $25 or any amount to help us to continue research and to provide you with the appropriate relevance that will fit your case. And thanks for joining us today. On this page, we provide additional links to other videos that you can review if you haven't done so. And thank you for joining us today. Bye.